All right, good afternoon, everybody, and welcome. My name is Joseph Blocher, and along with Daryl Miller, I am faculty co-director of the Center for Firearms Law. Before we get started, I also want to introduce our new executive director, sitting in the front row here, Jake Charles, also a Duke Law alum, good person to talk to about the work of the center or clerking and lives in academia, and so on and so forth. We're really happy to see so many of you here today and to have a chance to talk about the past, present, and future of gun rights and regulation in the United States, and specifically focusing on the Second Amendment and the Supreme Court. We have a truly awesome lineup here, myself excluded, to discuss that topic with. When I say discuss, I really mean it. We're not gonna have formal presentations up here. We're just gonna have some Q&A and discussion. We have lots of time for questions at the end, so be sure to go ahead and get those ready. I want to very quickly introduce the rest of the panel here and then start the conversation off. On my far left, we're joined by Sandy Levinson, who is the Garwood Centennial Chair in Law at the University of Texas Law School. He is without any doubt one of the preeminent constitutional thinkers of our time, has authored more than 400 articles and commentaries, a dozen books, one of which actually I see Walter has a copy of right here.
May I do a slight infomercial?
Please do. If you don't, I will.
This is written in stone by Sandy Levinson. 20 years ago, he looked at the issue of monuments and memorials and what their meaning was and the interplay. And now he has, at the request of Duke University Press, done a new edition that is just out this fall, a new edition written in stone that takes account of all of the recent controversies. The cover is the statue of Robert E. Lee being removed from in New Orleans, the giant statue. And Sandy has assessed these, and he's going to speak at 4 o'clock today or have a colloquium on memorials and monuments and the names of buildings and colleges. And he'll do that at 4 o'clock at some room.
3171, which will also have snacks and drinks. You'll notice this is actually an introduction of a theme, that Sandy writes something and then 10, 20, 30 years later it becomes front and center for everybody else. He got there first. That's one example. Another one we'll talk about, and maybe relevant to the discussion we're about to have, is that exactly 30 years ago, Sandy published what is arguably the most influential and most cited piece of Second Amendment scholarship ever written, at least in the modern era, a piece called The Embarrassing Second Amendment, which we'll certainly have some time to talk about. To my immediate left here is our own Walter Dellinger, the Douglas Maggs Emeritus Professor here at the law school, well known to all of you, I'm sure. In addition to being a preeminent scholar here at the law school for many decades, he is also a legendary appellate litigator and government lawyer, head of the Office of Legal Counsel, acting Solicitor General during the Clinton years, and of course, very close to home for the topic of this panel, he represented the District of Columbia in District of Columbia versus Heller. So many thanks to both of them for being here, and in addition to thanks to all of you. And one final thanks, actually, before I get out of the way, which is a thanks to the Supreme Court, who, after we scheduled this panel, granted cert in the Second Amendment case. We had not anticipated that. It's been a long time since the court has heard a Second Amendment challenge, but after we organized Sandy's visit, the justices agreed to hear a case called New York Rifle and Pistol Association, which we'll get a chance to talk about here today as well. To get us started, though, I think let's maybe start a little farther back. We could pick up the story really anywhere, but the 30 years ago is a pretty good time. In 1989, Sandy published in the Yale Law Journal this article, The Embarrassing Second Amendment, which, as you were saying just before the panel started, will be the thing that probably, at least in your scholarly obituary, will be listed as one of your major achievements and contributions. I wonder if you could just say a bit about what inspired it, what the state of Second Amendment law and scholarship was then, and what you argued in the article.
The inspiration was, in a sense, kind of misleadingly easy. I was invited to participate in a program at Williams College on the Bicentennial Bill of Rights. And I had taught First Amendment and really had nothing new to say about First Amendment, wasn't particularly interested in delving further into the law of regulating billboards as against leaflets or the increasingly nominalistic case law of the First Amendment. and realized that I've always been kind of vaguely interested in the Second Amendment. Largely, what was it doing there? And so I always accept invitations, and I said, I'll be happy to come to Williamstown. My daughter was then attending Williams, and why don't I write something on the Second Amendment? So I did, and found it really, really interesting, and thought it was worth writing up. How it got into the Yale Law Journal also has an interesting backstory, because I was informed later that what put me over the top in terms of acceptance was an accompanying piece by Wendy Brown, which was kind of an anecdote about being, somewhere camping or in a wilderness area, and maybe her car died or something like that, and she actually got help from somebody who was clearly an NRA member, and part of it was a very interesting story about her suspicions of this guy who really did turn out to be, a friend in need. And so they wanted that, and in order to publish that, they published mine. And it says a lot, I think, about the way the Legal Academy works, that for better and for worse, especially 30 years ago, it's very pedigree-driven. So the identical piece could have been published in literally hundreds of other places and basically gotten no attention. It's the fact that it was the Yale Law Journal that got it the attention, and probably the fact that I'm a political liberal, teaching at a relatively elite law school. So you can't ignore those aspects in addition to whatever intellectual strengths and weaknesses, because there wasn't much that was original in the piece. What I did was to read some of the literature, say this is interesting. I think I do have something to say about what makes the Second Amendment an embarrassment to political liberals who generally are Bill of Rights oriented and then want to pretend that the Second Amendment isn't there. So, so it's one of the things I was really interested in is what is it doing there? And I do think that the explanation has to do with a theory of a right to resistance against an oppressive government. The chief opposition to the Constitution was led by people who correctly viewed the 1787 Constitution as creating a consolidated national government that was a threat to the kind of federalism they knew and loved, and that Ernie Young still likes to defend on occasion. And that's what they were thinking of with regard to right to bear arms. I'm sure we'll talk about Heller in a few minutes, but one of the reasons I really continue basically to loathe Scalia's opinion, though not the result, is that he turns the Second Amendment into a liberal amendment about individual rights and individual self-defense, and wishes to elide the much more ominous and interesting background in 17th, 18th century civic republican thought and the right of the people to overthrow what they believe, rightly or wrongly, to be a tyrannical government. So that's a longer answer than you wanted, but that's the background. I was lucky. If Wendy hadn't submitted her piece, who knows where it would have been published and if anybody ever would have read it.
No Sandy, no Heller.
No. Another theme we'll come back to. Let me say one word on that, though, quickly, Sandy, and get it back to you before we get to Heller. I mean, I think we probably shouldn't understate how original the substance of the article was. There were people like Don Cates who'd written articles somewhat like yours, there's some themes maybe before, but what you did was original, and the landscape against which Sandy was writing at the time is one in which there are no Second Amendment cases of note endorsing this individual rights keep and bear arms view, or the anti-tyranny view really for that matter. There's bits and pieces in the cases which you excavate pretty well, but the scholarship is all but either advocacy or dead at the time, and that really did kind of change. So I wonder if you could say, before we talk about how the courts will eventually approach that question, how your argument was received by the sort of those liberal professors at elite institutions that you're talking about.
You know, most of my friends and family were appalled by the article. The consensus at the time was that Chief Justice Berger, otherwise not particularly viewed as a source of great wisdom of constitutional meaning, in an interview in Parade magazine, also not usually viewed as a great source of academic insight, had pronounced the NRA's views of the Second Amendment to be a fraud against the public. And that was quite often quoted by, you know, impressive people in impressive venues as pretty much right. So my piece was an embarrassment insofar as it suggested that there, actually without particularly applauding the NRA's view of history, because for reasons we can get into, I think the NRA is much too liberal, classically liberal in its view, whereas what really interests me is the civic Republican, let's overthrow an oppressive government view, which for obvious reasons is much less likely to gain purchase in, you know, the general court of public opinion than one saying that it's all about the right to protect yourself against criminal in your own home. I think if I had a comparative advantage, it's that I had gotten a PhD before going to law school, and I was interested in political theory. You know, I think it's just a truth that most people who had written about the Second Amendment, certainly up to that point, were not particularly interested in political theory, though they certainly were interested in excavating for their own basically advocacy uses certain documents of 18th century thought. But what interests me, if there was anything original in the essay, it was actually to take issue with Max Weber, who had defined the state analytically as possessing monopoly over the means of violence, the legitimate use of the means of violence. And it seems to me that the most interesting thing about classical civic Republican thought is that it rejected that view of the state because the means of violence were to be legitimately held in some sense by we the people, who could, as a collectivity, to quote Lin-Manuel Miranda, rise up against an oppressive government. And, you know, I think that Weber was a German statist and that the Anglo-American political tradition is anti-statist. And the Second Amendment is an especially interesting way of getting at that reality.
Let me say a word about Sandy's article. It had an enormous impact. The fact that it's not just that Sandy was seen as politically liberal and the University of Texas and published this in the Yale Law Journal, but he was also held in incredibly high regard, even as a relatively young professor at that time. His case book on constitutional law with Paul Brest of Sanford was the one that I immediately used, and I thought it the best constitutional law case book I'd ever seen. So there was this influential liberal had said, hey, liberals are embarrassed by the Second Amendment because they're not reading it and they're not taking it seriously. I was struck on rereading it, Sandy, and wee hours of the morning, that you're quite cautious about not being definitive about what you think the final best view is. What the article really says is that liberals are not grappling with the Second Amendment. They're not addressing these issues, and he is making the argument that they should, because there's a strong case to be made for a kind of individual right and a right against tyranny that is being ignored. I do remember someone at the time saying that the sort of short answer to Sandy's argument was, or the short version was, that if liberals interpreted the Second Amendment with the same method they interpret the rest of the Constitution, there'd be Harvard law professors arguing that every individual had a right to a government-funded gun on demand.
That's true. It is a marker. It is another marker of the influence here is that, and I won't say it's all causal, but in the decades after the embarrassing Second Amendment, you saw other prominent scholars, the sort of Lawrence Tribes and Akhil Amars of the world, come around to a view that recognized not exactly the civic Republican ideal that Sandy's describing, but something like it. The Department of Justice announces for the first time in 2000 or 2001 that it's endorsing some view of the individual right to keep and bear arms that is a right that's not limited just to people serving in an organized militia. So if we fast forward a little bit from there, it's 20 years now after the article, when we're in the sort of fall of 2007, and I should say, full disclosure here, I was working for Walter at O'Melveny and Myers, and Walter asked me, because he had a case coming up, what I knew about the Second Amendment, which was an easy question to answer because it wasn't taught in law schools at the time. There were no real federal reported cases of note. But Walter, I wonder if we fast forward a bit, if you could say kind of what the state of play was then. We had this case then called Parker working its way up through the D.C. circuit.
It's interesting because we went from the background against which Sandy was writing, that the Second Amendment was dismissed in 1939 by a unanimous Supreme Court in U.S. versus Miller, saying only rights that are related, have a relationship to the effectiveness of the militia are covered by the amendment. We had a really relentless public relations campaign that shows how it can influence, so that by the time I came to argue Heller, it was seen as an uphill argument when the one and only precedent was a unanimous Supreme Court decision clearly in our favor, which just shows
James McReynolds.
by that known liberal McReynolds. So it shows you how the ties of public opinion, and I think it's true with causes on the liberal side as well, but this is the single greatest example of public opinion influencing judges. The Federalist Society, which I often spoke, almost every year had a big panel on the right to keep and bear arms. I mean, it was sort of became part of the discourse of the people that were to become judges and justices, so that we had agreed to be, the case was being handled by the Corporation Counsel for the District of Columbia. The Court of Appeals, the D.C. Circuit, had struck down the district's prohibition on the possession of handguns in the district. And the lead plaintiff in what was to be Heller argued that, in particular, that his right to possess a gun in his own home was protected by the Second Amendment, and he won in the D.C. Circuit, in a fairly sweeping and muscular Second Amendment on steroids opinion by Judge Lawrence Silverman. So we agreed as a pro bono matter to be co-counsel and help the city argue the case of the Supreme Court. That year, the Corporation Counsel sort of had a professor in residence, the very, very great Alan Morrison, who's often taught at Stanford Law School and Georgetown and others. Alan was a great Supreme Court advocate. He and I had argued the line item veto case against each other when I was in the Solicitor General's office. This is sort of an interesting story about law practice, because we helped out on the briefing, and that was mainly Joseph's responsibility on the merits briefing. But not long before the scheduled argument, Alan, this is all public knowledge, Alan had a falling out with the Corporation Counsel over a footnote from which neither would back down, remember? And Alan either quit or was fired, so they were without a counsel, and Washington Post was to write a big editorial about how the district had handled the case, and at that point, the Corporation Counsel called and asked if I would argue it. And I had, as Joseph knows, two other cases to argue in a 4-week period, one an energy regulation case and then a $5 billion Exxon Valdez case.
You know the Exxon case probably from remedies or torts. This is at the time the largest torts judgment.
I had both. This was going to drop right in the middle, I think, or of those arguments. So there was going to be scant preparation time. When I was at a scoreless tie with Joseph about how much we collectively knew about the Second Amendment. I do recall it's one last scene setting about that has to do with how much public attention this got. And I think the argument was on a Tuesday. Possibly Monday, I think it was a Tuesday, but Sunday afternoon, I was in the office preparing, and I decided to turn on the local news at 6 o'clock and see the sports scores of the day. And the news led with a reporter live at the Supreme Court where people with sleeping bags were lined up a day and a half in advance to get into, and I thought, I got to turn off the TV and go back to preparing. You know, I sort of welcome this opportunity, first to be reacquainted with Sandy's scholarship, but also to go back and look at Heller. You know, I sort of read the opinion with one eye closed, but I've refused all opportunities to speak about Heller or Second Amendment issues ever since. And yesterday afternoon, I listened to the oral argument, easily available on oyez.com, or oyez.org, oyez.org. All the arguments are available, and it wasn't nearly as bad as I remembered. What was it? As we said, we made, with one exception, we made all the points we needed to make. The one exception was the state constitutional provisions at the time. Your colleague had done a binder of the state constitutional provisions, and for something that I could look at, was sort of a tertiary thing. And it turned out Stevens asked about it and thought it important and knew a lot more about it than either I. Fortunately, none of the other counsel knew much about that either, on the other side, that even Paul Clement.
I should say, one of the things that was interesting about the oral argument, we were getting ready for it anyway, was that because there wasn't any precedent coming from the justices, it was very hard, I thought at least, to kind of guess where they were going to be. So the oral argument, in some sense, was the big reveal. It's not as if they had, like, you know, like First Amendment, you can predict where they're going to go on this issue based how they ruled on other ones. So that morning really was kind of, well, what's Justice Kennedy's first question going to be? And I'm not sure I've even told you this, but that morning, when all those campers were out there in front of the Supreme Court, I was waiting with, I think, the mayor and counsel for you to come. Walter travels to court on bicycle, which I did not know. And we were sort of sitting in the downstairs getting a cup of coffee or something like that, and they're like, where's our lawyer? Walter pulls up on the bicycle, takes off the helmet, strides into the court.
Right.
Can you say a bit more about what the actual experience of argument was? It's rare we get a chance to actually talk about it.
Yeah, I'm trying to decide whether to do a little bit of the substance to set up the Kennedy question, but when you don't know where the court is going to come from, since everybody in the 1939 case was long dead, you know, it just hits you when Kennedy asked me a question that I thought got the history so completely backwards. I just wanted to say, let's just leave early for lunch. I'm just wasting time here. But that was the sense. I think you can hear me sigh in the audio recording. But let me say just a little bit about the merits, which I think are close. First of all, there were at the time of the founding 3 different kinds of discourse that were going on around guns. One was the militia and the need to preserve the state militias, and therefore the need for them to have access to guns, the militia right. There is what Sandy calls the individual liberty right, the libertarian view. that possession for your own personal purposes, including self-defense, is very much part of the discourse as well. And the third is the one that fascinates Sandy the most, because in his deep soul, he's a revolutionary. He wants a new constitutional convention, okay? That's another discourse. The third discourse is the use of guns to be available against tyranny, so that there is for the resistance against governmental oppression. And I think what makes it difficult to decide what the Second Amendment was about is that you can pluck from all three of these different discourses that are going on. And so, I mean, one of my bottom line arguments would be, if you can't tell, then five guys ought not to overturn democratic judgments if you just can't tell what the answer should be. What is the basis for the court to invalidate then and later the laws of a lot of states, as well as the District of Columbia. On the tyranny rights, here's where I think I differ from Sandy, though I'm not at all sure that I'm right, but here's where my thinking is. So I taught constitutional history here, and I taught the third of it. There was the debates at the Constitutional Convention, and the ratifying. I read all the ratifying debates, and then the debates in Congress over the Bill of Rights. Didn't find much on the way of ratification materials on the Bill of Rights, but I did the ratification materials on the Constitution. So here is where I think the Second Amendment originates. There was a provision of the Constitution that was one of the two or three most hated when it was proposed and sent to the public, made public for the first time and submitted to the states on September 17th, 1787. And that was Article 1, Section 8, Clause 16. There was, the Constitution was nearly not ratified. It literally had to come from behind in the critical states of Virginia and New York in order to gain ratification, where there was very strong opposition that saw the creation of a national government in some faraway national capital. It'd probably be easier to get to London by ship from Georgia than to get to Philadelphia overland, so that the national government seemed like what we were fighting the Revolutionary War against, okay? So the Clause 18 provides that Congress shall have the power to shall have the power to organize, arm, and discipline the state militias. Organize, arm, and discipline them. The states could name the officers, but the training had to be in accord with the discipline established by Congress. This is against the background that it also allowed Congress to create, in 2-year appropriation increments, a standing army. So all of a sudden, there's going to be a standing army, which reminds one of the redcoats, right? And at the same time, militias, which were seen as the people in militia assembled. That is, the militias where people put down their implements of agriculture and trade and took up guns and organized themselves and went back to their ordinary occupations when the threat was over. So that militias were the people's resistance to governmental tyranny. Now, I think at that time, the states were seen as the repository of the people's liberty. There wasn't that much concern about state government, which was kept very close to home and were very democratic in most of the states, often one-year terms, recall, very tight control of the public, so that while there was a resistance to tyranny, I see it more as states being able to resist national tyranny. And therefore, to have nothing that would prevent the people of the state from forming themselves into a militia when needed. Story says at one point, the people are the militia are the people. He quotes Federalist Farmer as saying. So that I think this resistance to tyranny is not inconsistent then. So in any event, there was a huge outcry creation of a national standing army, giving the national government control over the state militias, there has to be an amendment. And when Madison promises amendments, this is one of the things he promises to fix. Now, this doesn't go to public meeting, but Madison was dragged kicking and screaming because he did not like state control over militias. He wanted at that point to have a stronger national government. And so he carefully writes the Second Amendment to give as little up as he thinks is possible. You know, that doesn't mean when people ratified it, they didn't have a different view. So that's why he says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, I think, and can never win this argument, that the people, you know, refers to the people collectively. You run into the Fourth Amendment using it in what's clearly an individual right, but I really have that sense that every part of it. So one of the problems of arguing a case like this when there's been such a public discussion for so long is that people assume you're going to argue something you're not going to argue. So everybody is waiting for me to start with the preamble, a well-regulated militia. And they're expecting me to deny that it creates any individual rights, which I thought was just wrong. The pro-gun control people have been saying it doesn't create an individual right for about 30 years, and I think that's wrong. And we were very intent on making that argument, that individuals could invoke the Second Amendment. The question is, what rights does it cover? Does it confer? That, and to start by saying we should start with the phrase keep and bear arms, which I think surprised everybody. Everybody was writing about how I was going to get up and talk about the preamble, a well-regulated militia, and then Alan Gert was going to get up and talk about the right to keep and bear arms. And we went right to, we were talking about, let's start with keep and bear arms, which in every instance that we could find, with almost no exceptions, was a reference to the military use. So much so that Madison in his earlier draft wanted to have a provision that those with religious scruples were exempted from the obligation to keep and bear arms. So that the idea that the militia would be of the people, it was a resistance of national tyranny. Maybe the militia is going to want to say everybody in the state should have a gun at all times. Maybe the militia wants to say every 17-year-old has to be trained in the use of a weapon. And any federal law which infringed upon that, the ability of an individual to participate in that, would raise a serious question under the Second Amendment.
Let me add one thing here. The federal law point's an interesting one, and worth noting that at oral argument there were three folks who argued: Walter, Alan Gura, Ford Dick Heller, and then Paul Clement arguing as Solicitor General of the United States. And Sandy, you've written about Paul Clement's brief and view, and this is jumping a little bit to the summer when we get the decision from the Supreme Court. Sandy, but I wonder if you could say a bit about, and here I want to invoke another one of your articles, fantastically titled, I have to actually just quote this one right, "Why didn't the Supreme Court take my advice in the Heller case?" Some speculative responses to an egocentric question. Could you tell us a bit more about the opinion where the court went wrong in your view, and maybe either bring in Paul's arguments or not?
Yeah. There are a number of ways, both of understanding that second article and my response. Now, I think that Heller helped to elect Barack Obama, and therefore an objectively good decision, whatever else one thinks about it. Had the four so-called liberals gotten Kennedy's vote, I think Obama's election would have been thrown into doubt, because what Heller did was to take guns basically off the table of the 2008 election. And Barack Obama could present himself as respecting the Supreme Court and calling on everybody else to respect the Supreme Court. And John McCain, to his credit, did not say, but you're only one vote away from overturning it. Guns were not part of it. So part of the plea was not to overturn the D.C. decision, which on straight political grounds I thought would have been most unfortunate. So that's one way of answering it. Then there's the more lawyerly answer. I did think that Paul Clement's brief was a terrific brief, in part because he invited the court to send it back to the D.C. Circuit actually to fill in some blanks, like standard review and things like that. And so, then one of the questions is, why didn't the court do that? Why did it end up the 5-4 split as it did, rather than to behave, I think, in a more cautious and thoughtful fashion? Because, to put it mildly, they hadn't thought about the Second Amendment any more than anybody else had. And they like to talk about issues percolating and stuff like that. There could have been a little bit more percolation. There was also the fact that, from my perspective, Heller really needn't have been a Second Amendment case at all. Walter mentioned that I try to take some care in the Yale piece in not pounding the table and saying, here's what the amendment means. I think it is stunningly opaque in its range of meanings. I also think that by the 21st century, or I would argue by the mid-19th century, there was simply no doubt that part of American constitutional culture was to recognize an individual right to keep and bear arms. One of the reasons I so loathe Scalia's opinion is that he insisted on shoehorning the Second Amendment into his own originalist hang-up. And so he presents a patently misleading history of the Second Amendment that would properly be returned had it been a seminar paper. But they don't write seminar papers. They get to make it up. He dares to cite Charles Sumner's 1857 Bleeding Kansas speech for the proposition that the settlers, the anti-slavery settlers in Kansas, have a right to bring their firearms in order to protect themselves against slave owners who don't wish them well. That's perfectly fair, except if you're an originalist, where it makes no sense to cite 1857 speeches for either original intent, original public meaning, or anything else that originalists talk about. It makes a great deal of sense if you believe in a living Constitution, but of course Scalia was a proud proponent of the dead Constitution. But where Scalia showed, for me, his lack of integrity was his refusal to cite what is by far the best source for the argument that every American citizen has a right to keep and bear arms for basically individual purposes, which is Dred Scott. I don't teach Marbury. Another article of mine is why I don't teach Marbury, and you shouldn't either, which has had no success, I can tell you. But one of the reasons I don't teach Marbury is I think it's a waste of time in terms of what it takes to teach it well. And I'd rather get the time to teach Prigg versus Pennsylvania and Dred Scott, which are infinitely more important and challenging cases.
One of the things that you know, I'm sorry.
Dred Scott is a truly Janus-faced case. Part of it is simply an abomination. I'm not going to offer a revisionist argument with regard to its racism. But another part of it is really quite inspiring in terms of its assumptions that if you're an American citizen, you really get a meaningful bundle of rights. And one of those, part of that bundle is the right to keep and bear arms. That's just what Tawney says. It has nothing to do with militia. It has nothing to do with rising up against an oppressive government. He actually doesn't tell you exactly why you got that right, but you do. And so I teach Dred Scott under the following syllogism. All citizens have a right to bear arms. That's what Tawney says and assumes. along with Sumner, both of them agree in 1857, it is unthinkable that blacks could have a right to bear arms. Therefore, blacks can't be citizens.
Right.
The logic follows. But you begin with a major premise that if you're a citizen, you have a right to bear arms. So I think you can call it a Ninth Amendment right, privilege or immunity of U.S. citizenship, and you don't really need to get into the weeds of trying to discern the one true meaning of this notably opaque patch of text. But, why didn't Robert, there's so many contingencies. Walter mentions one, that he emerges late in the game to be the lawyer. The fact is, there's a terrific book by Adam Winkler called Gunfight, it ought to be called Gunfights, on how the NRA didn't want to bring this suit because they couldn't count to 5.
Right.
So that Heller is a wonderful example of how, in essence, freelance lawyers who hit the wave just right can get to the Supreme Court. Same thing is true of the gay marriage cases in 2004, that nobody controls this. And that's an important part. But another part of the contingency is it was up to John Roberts to assign that opinion. Why did he assign it to Scalia? If he wanted an originalist opinion, he should have assigned it to Clarence Thomas, who in fact had exhibited some interest in the Second Amendment. My hunch is that he didn't think that Thomas could necessarily preserve the court because he might not compromise the same way Scalia compromised. And Scalia compromises by a series of ipse-dixits with no reasoning whatsoever to back up the proclamations that do not worry. Every existing federal regulation of firearms is just fine, including preventing Walter's former client, Martha Stewart, from having a gun. I think Martha Stewart is constitutionally entitled to a gun. I don't care that she's a convicted felon because what she was convicted of was not a violent felony. I also believe that undocumented aliens have a right to possess firearms if you buy the liberal reading, that is the self-defense reading of this Second Amendment that Scalia gives. So it's a terrible, terrible opinion. But Roberts deserves a great deal of the blame for assigning it to Scalia and then being a good sport in signing it. One side piece for 30 seconds. There's gossip that Clarence Thomas might actually resign in the next couple of years. If that happens, my hunch is that one of the reasons is that Thomas realizes that he has never, in his now 25 years on the bench, been given a major opinion to write. And he is unlikely to be given major opinions to write in the future. There are majority opinions he's written. I suspect that none of them appears in case books or is taught. There are interesting dissents and concurrent opinions that he's written, but I think after 2 decades on the court, you want to be a player and you want to get your share of majority opinions. And so, I'm not going to be alive to write this, but when all the archives come open, part of the question is who voted to grant cert in this case and what were they thinking? The whole conduct of the various lawyers, that is the NRA versus Gura, Alan Morrison's falling out, Paul Clement's brief and the fact that it was simply ignored by the court. But one of the things I'm interested in is why in the world Roberts thought it was a good idea to assign this.
All right, let me just add one to go back one step and just briefly add the point about the individual liberty right. have always thought that the better source of the right for the possession of a gun are the due process clauses of the Fifth and 14th Amendment. And that's where the arguments should lodge, and you would certainly draw upon the fact of the common law right of self-defense. And the common law right of self-defense cannot be effective in many circumstances and situations if you don't have a gun. But I think that invoked a kind of reasoning. It got too close to Griswold and Roe, for the comfort level of those who sort of politically supported gun rights, wanted to be able to, I think, find some text to say that we're bound by some original text, when I think the text is indeterminate, I would say, with some distance from having been in the throes of argument. I do think it's tough, but I think it, to me, it makes the point that originalism, which is often said is a constraint, a restraint on judges, because they have to apply the original meaning. I think it's the reverse. I think it liberates judges to impose their own views because they can attribute it to someone else and they don't have to defend it. The way the great opinion by John Harlan and Poe against Sullivan became his opinion by referencing Griswold against Connecticut. He explains and takes ownership of why he believes that sexual intimacy in marriage is so fundamentally important that a government would need an especially strong justification. He lays it all out for you. He doesn't pretend that he's just a machine, which I think liberates judges. But I think you're going to want us to go to where we are now.
Yeah, I'll be quick catch up where we've been and then where we're headed. So what we've gotten so far is this discussion, scholarly, legal, political, kicked into motion in part by the publication of Sandy's article. 20 years later leads to this decision, repeatedly described as opaque, but kind of like a forceful, confident opacity, I'd say, to the opinion. It's not at all the way that Sandy's own article is, that the court is very, very sure of its conclusions, but doesn't do anything like articulate, for example, an overarching test, a scrutiny, identify one of the tiers of scrutiny or anything like that. Instead, they leave that for the lower court. So the percolation that Sandy was describing kind of happens ex post, as after Heller, we have more than 1,000 cases in state and federal courts in the 10 years after Heller, generally congealing around some common features.
You just mentioned my title.
This is going to be this is the final one, your next called shot. So what we also have is the court repeatedly rejecting cert for Paul Clement, now often representing the NRA, filing cert petitions over years, dozens of them, by he and other advocates, and the court is just turning down every single one, which tees up Sandy's most recent Second Amendment article, the title of which is "Too Damn Many Cases and an Absent Supreme Court." That was written over the summer. We invited Sandy in the fall, and then a few weeks after that, again, Sandy calls his shot, and again, the court listens and grants cert in this new case, New York Rifle Pistol Association, which involves a very strange New York City law. As far as I can tell, unique. I've never seen another one like it. But that kind of catches us up to where we are. Sandy, do you care to tell us where the Second Amendment is headed, or Walter, do you have thoughts on the case?
I can't count to 5 on this one.
Either way.
Yeah. There's this really stunning article on the 1,000 or so cases. And one of the points I make, if you believe in doctrinal analysis, and let me tell you quite frankly, I'm not known for being a doctrinalist, but if you do believe in doctrinalists, then just as psychologists say that you really can't remember more than 7 things or 7 numbers, if you're going to do doctrinal analysis, there really shouldn't be more than 7 cases, which you can try to blend together. If there are 1,000 cases, that is too damn many cases. And of course, only 2 Supreme Court cases, which are notably unhelpful in answering any of the questions, because there's no explanation why Martha Stewart can't have a gun. There's no clue as to what your level of scrutiny should be. And then in
You should see her temper, Sandy. Before you go really much further with this, I'll leave that for, I can't, more than that I cannot say. But,
and McDonald turns out also to be a fairly mechanical decision where there the mechanism is just incorporate it because it's unthinkable that the states would be held to a lesser standard, though I've publicly described Frank Easterbrook's opinion for the Seventh Circuit as the best 11-page opinion that's ever been written, in which he just ridicules. And of course, if Easterbrook isn't familiar to you, he's a very, very conservative former University of Chicago law professor who's been in the Seventh Circuit forever. And among the things he points out is that if you in fact like federalism, then you might believe that state and local governments are more appropriate venues of regulation. You know, if you're Vermont, you might very much want to be quite freewheeling. That's why Bernie Sanders, until recently, always treated the NRA well. But if you're concerned about Washington, D.C. or Chicago or the like, you might have a different view about the availability of firearms. And Easterbrook thought that was fine. You know, obviously the Supreme Court disregarded that. So the point is you have all these cases, and nobody can make sense of 1,000 cases that go in very different directions. There have been some genuinely fine opinions. There was an opinion, particularly the Third Circuit, on felons in possession in Maryland that was, if you do believe in law and doctrinal analysis, they were models of what analysis should be like. It didn't matter. The Supreme Court denied cert. And the Supreme Court did deny cert. And I don't think the Second Amendment, I think Thomas is wrong not treating the Second Amendment as an orphan, because the Supreme Court in our lifetime, and when Walter clerked, the court was probably taking 150, 170 cases a year and issuing opinions in 130 cases, and now they're down to 70 opinions. Each justice is responsible for writing about, you can do the math, about 8 opinions for the whole year, and then the concurrences and dissents. And needless to say, they don't really explain why they take the cases they don't or not, they do or not. And so they had been absent. Now, this case really is an odd case. And one of the reasons I can't count to 5 is that one can imagine all sorts of reasons for an extraordinarily narrow opinion saying that this New York law really is kind of silly, a little bit like Stewart's view of Griswold, and it's unconstitutional for that reason. Or Richard Posner kind of called the bluff. Posner wrote this, assailed Heller after the decision. And then he turned around and said, well, if you take Heller seriously, I think with tongue in cheek, then it requires that you be able to carry guns wherever you want, because after all, if you're really concerned about self-defense, it's not only your home, it's anywhere you go. I mean, you live in the kind of Donald Trump society where you can be attacked at any moment, anywhere, then you want to have a gun that you can defend yourself. And he said, well, this is the way I read Heller, just baiting the Supreme Court. And the Supreme Court hasn't taken the bait. And, who knows what the Second Amendment means.
I differ with both of you that there's anything weird or strange about the New York case. It's sort of shaped that way in the cert petition on which cert was granted, but it's simply, the question is, what kind of exceptions need to be made? I mean, the law is quite simple. It's a prohibition on public possession of a gun in public, and doesn't touch the home. Now, there's some, if you take it literally, you could raise some questions about that, and I'll come to that in a minute, but one of the things that struck me about looking back at this, we won Heller. As far as the district is concerned, because what they cared about was carefully not reached by Scalia, because what they cared about the ban was on possession of a handgun anywhere, even in the privacy of your bedroom. What they cared about was guns in public. Okay, and for the DC police, it's the single most important law enforcement tool that they have. Because people do not go out to commit burglaries and robberies and murders carrying a knife. They carry a handgun, or a rifle for that matter, on the metro. They carry a handgun. And if public possession of handguns is prohibited, then they get somebody and they don't have one of the special licenses that entitle you to do it. They've committed a felony. And there's a lot of enforcement of that law. When you can't find out whether they did the burglary or didn't, you got them because they're out in public with a gun. And so that's what the DC police chief really cared about. And by leaving open, Scalia leaves open in a tantalizing sentence. We know we protect the right in the home now. He leaves open whether, he said, we don't call into question the state's right to, and localities' right to limit handguns in sensitive public places like schools and courts. He literally but that leaves open is, well, what about, in an urban area, aren't all places as sensitive as that? That is, the crowded subways, not just schools and government buildings, but crowded subways, it's not like you're riding across Wyoming. Can't you declare the 5 boroughs of Manhattan to be a sensitive area in the sense that Scalia meant? And so, I mean, the game of the cert petition is to take the statute literally and then to find some absurd applications if you applied it literally. So what if you have a second home? It's interpreted to apply, and sometimes the interpretation comes from the police, but that may be temporary. What if you have a second home? Can you not transport the gun to your second home? Well, that would be a stupid way to read the law or for the law to be applied because it would require you to keep a gun at each place, meaning leaving a gun in an unoccupied, forest dwelling is not a good idea for teenagers to break into. It's better to have the gun and take it with you in a lockbox. What if they don't keep it in the lockbox? Well, you can ticket them for that. So my view is you've got to protect the second home. That doesn't, saying you've got to protect the second home and let people therefore travel, right? And the other exception, you're allowed to go to your training at a gun club and gun training, which is would be an important penumbral aspect of a Second Amendment right, to be sure. Well, there has to be an authorized gun place. It's authorized. And the police say the only authorized places within the 5 boroughs of Manhattan. So you can't go right across the river. Well, they could change that. They could say you've got to consider applications from outside the 5 boroughs if they show they're meeting a need that is not served. If you take care of those two problems, and I have some involvement in this. If you take care of those two problems, what you're left with is a simple ban on public possession, which is the big issue. I think greater practical consequences than the laws at issue in McDonnell and in Heller. This is the big question of whether those localities that choose to do so, Wyoming is not going to do so, Oklahoma is not going to do so, North Carolina is not going to do so, but whether some cities or localities or urban areas can say you can't have guns in public places. And that, I think, is going to be the big issue that is going to be decided. No, because I don't know. I can't. I'm neither optimistic nor pessimistic about this case. But they did take the case. So that was the city had hoped to say, move along, nothing to see here. But again, Paul Clement did an excellent job of pointing out these idiosyncrasies at the margin of the law, to which my responsibility, as it was in Heller, get rid of the idiosyncrasies. You could read the D.C. laws. You can't leave your gun within your own house. Well, we don't read it that way, And if you want to hold that would be unconstitutional, it's fine with us. The same with trigger lock. We didn't care about trigger lock, so it's just unenforceable. Right? What makes trigger lock enforceable is that they give you a free trigger lock for your gun. That's what's helped spread trigger locks, not the requirement that you have one, which has literally never been enforced. But the court wanted to use that as a way of saying, well, there's no gun that can be effectively used. We want to say, just throw us into the briar patch, get rid of that. But the intensity of one last thing, to give you a sense of the intensity of the feeling about this, Heller was so teed up to be the great American gunfight over the Second Amendment that there was an argument that everybody said, you tell me you can't make, because everybody's teed this up to be the great Second Amendment case. And that is, whatever you think of the Second Amendment, I want to argue, it can't invalidate gun restrictions within the District of Columbia, done by Congress's delegee. The city council operates under the authority of Congress, with Congress having the authority to disapprove anything. When the Constitution created an area not to exceed 10 miles square, it was crazy to make it that big, to be the seat of the national government. The idea that Congress couldn't regulate weapons within that 10 square mile area, like they can regulate them on Fort Bragg, I think is a debatable proposition, at least. I wanted to argue that whatever else you said, Congress, whatever limitations on Congress is a national legislature affecting rights in Wyoming. This is the District of Columbia, where they've got sort of plenary power over security of the national government. But everybody said, no, they don't want to hear an argument that this case is just going to go poof because it only applies to the District of Columbia.
You all will see how the next chapter unfolds. The court will hear argument in the New York case next fall, we think, so an opinion by the end of next term, and you all are now fully equipped, know everything you need to know about the backdrop of Heller itself, and at least part of the aftermath. So please join me in thanking Walter and Sanford.